the Election Petition Tribunal said that 25% vote in Abuja is not compulsory, that Abuja is not special than other states. See the way Vanguard reported, 25% votes, Abuja not special than other states. Tribunal dismisses Obi's claim. The Presidential Election Petition Tribunal, led by Justice Tsammani, has said that the Federal Capital Territory has no special status over other 36 states of the Federation over the 25% required vote in the presidential election held on February 25th. So this is what the PEP said today. This is their ruling that FCT is not a special state. FCT is the same thing as every other state. But remember that Section 134, subsection 1 and 2 of the 1999 Constitution of Nigeria, as amended, states that a presidential candidate must attain or score a majority of votes cast in a presidential election where 2 or more candidates are involved, and at least 25% in 2/3 of the 36 states, and FCT to meet the constitutional requirement to be declared as duly elected president of Nigeria. This is the law. I don't know what this particular Presidential Election Petition Tribunal, what they are taking Nigerians for. We know the law, and the interpretation of this law is very simple. There is no special interpretation to it. It states that, and the FCT, it didn't say the whole 37 states. No, we know that in Nigeria, FCT is a standalone because of how important it is. I will allow us to watch this video and understand that what the PEPs did. So guys, in their judgment today, the election petition does not have any special status as FCT and no special voters in Nigeria. There goes the 25% in FCT, clearly stated in the Constitution. That's it. Something that is clearly stated in the Constitution. We are not saying there's no special voters anywhere. Another person here said Justice Tsammani have just ruled that FCT is part of the 36 states envisaged by Section 134, subsection 2 of the Constitution, and the failure to score 25% is irrelevant. Issues 1, 2, 3, and 4 are all resolved in favor of the respondents. Our Constitution have been sold to the highest bidder. The Constitution is very clear. You must have 25% of vote cast in FCT to be declared the president of Nigeria. Yet our judiciary have failed us. Our judiciary is upholding someone in power who did not get up to 25% of votes in Abuja. JP here said they failed Nigerians. We gave them the benefit of doubt and they failed as they have always done. Hashtag PEP's judgment. It's simple truth. Nigerians believed in them. Nigerians were believing that since the evidence is already very clear, since Peter Obi and the Labour Party have presented their case clearly to the court and to Nigerians, and we know that truly something might come out, but at the end of the day, the Presidential Election Petition Tribunal, led by Justice Tsammani, failed Nigerians. Another person here said all judges are sold out. If anyone had any doubts, all those doubts should be removed after today's verdict. These judges were openly defending Tinubu than his lawyer ever did. Nigeria is a country where the establishment is the law and money is the religion. This lawyer here said the Supreme Court is the final arbiter on presidential election petitions. The Court of Appeal has taken a position. We will see how the Apex Court will look at the issues. That's the simple truth. We will not stop here. We will go over to the Supreme Court and justice must be served in this particular case. How will you say Abuja is just like every other state? That 25% in Abuja does not count. How?
There was also that thought, wondering, so when they broke all of these things down, as you also describe it, what more can the Supreme Court do? Because if it's really this clear, many just wonder, it doesn't make it, somewhat easier for Supreme Court to decide upon.
They have taken their positions on these issues. And many Nigerians do not agree, and legal practitioners, with their position. So it makes it easier for those who felt shortchanged by the judgment to look at the facts, look at the law, and then lodge the proper appeal at the Supreme Court for them to have the final say. So it even makes it easier for the appellants to find out exactly what they're complaining against and then present it before the court. It will even make the work of the Supreme Court easier.
We also had Chris Uchesi and demanding for the judgment
certified true copy.
Yeah, yes. that day.
Yes.
So that because that time.
Yeah, that time. I mean, between now and 60 days, the Supreme Court must give its judgment, and the earlier you go before the court, so that they start looking at the materials, the better.
What did you think about the live coverage?
Well, if you recall that at the beginning of the proceedings, some Nigerians had demanded that they wanted to have live coverage of the tribunal proceedings to get a blow-by-blow account of what is happening, how evidence is admitted or rejected, or how they have been interacting with the parties before them. But they turned it down that it's not a comedy session, it's not a drama session. So some of us are wondering what actually changed when it came to the time of the judgment. Because if you understand the law properly, when a court is trying a case, particularly a case of such national significance and importance as this, the court is also on trial. It is the prerogative of reasonable men and women to sit back and decide to watch even the demeanor of the judges and how they are performing their judicial duties, as to form their own opinion whether justice is being done, because the justice is not just what you did on the last day. It's a continuous exercise. What you did on the first day built up into the second day until you were ready to read the judgment. So some of us were wondering what exactly changed between that first request, which was turned down, and this one, which on the court on its own, so much the court, there was nobody who applied. The court on its own now said everybody should come, everybody should watch. We are ready to read the judgment. So I thought that they would have allowed this live proceedings from the beginning of the case up to the conclusion.
Because many say, look, why is it that Nigerian judiciary took this stance? And for instance, in several countries across the world, several high-profile cases, they see what transpires, blow-by-blow account, they see the faces of the judges, but they don't see their faces.
Even yesterday, I hardly saw the face of any judge. I don't know if I'm right or wrong.
You're very right. That was the directive. That
yes, nobody.
Just let the camera stay.
So what exactly were they hiding? There are things that raises questions. These are Nigerians. Many lawyers know them. Many people know them. What exactly were they hiding to say, don't put the camera? Because even the idea of you hearing a voice without seeing the person, the reading, the face, the gesticulations, even the way the person looks, makes it look somehow like an artificial intelligence kind of proceeding. There was absolutely no reason why we shouldn't have seen them. And nobody, there was no provision of the law, no rules of court that said that their faces should be hidden. Why do you have to hide if you know you are doing the right thing? So some of these things were questions agitating the minds of some Nigerians yesterday.
Okay, so to some of the highlights now. So yesterday, many thought, will there be one dissenting voice, two dissenting voices, but they were disappointed. And then they highlight the consolidated petitions all dismissed. And the way and manner that it came through as well is what several reactions, 25% votes in the FCT, not compulsory to have that. Shatima validly nominated, even Itobe himself validly nominated by Labour Party. So virtually no case submission.
Well, what happened yesterday did not start yesterday. It's a culmination of the understanding of the jurisprudence of electoral dispute adjudication from the Obasanjo days. The courts have been doing it up till yesterday. Now, I say with utmost respect that why we will continue, or why these kind of decisions are coming from the courts, is that the courts have failed to ask a simple question. What is the purpose? What is the goal of electoral dispute adjudication? if I may provide an answer, it is to determine who actually got the majority of the lawful votes from the electorate. Since Section 1, subsection 2 of the Constitution says the Constitution is supreme, nobody should take control of the whole federation or any part thereof in a way and manner not in accordance with the provisions of this Constitution, which means you can only lead or purport to lead by virtue of the votes. But that hasn't been happening. What has been happening is that the judges, not just this panel alone, usually go what I call a wild goose chase, put adjectival law, put all kinds of challenges and obstacles on the road. So they are not actually trying to determine who won, but it's like who can display more of the knowledge of legal technicalities and gymnastics. Let's look at this way. The petitioners went to court. For the first 2 to 3 weeks, the court gave an order to INEC to provide them, give them access to beavers and materials. It took almost 2-3 weeks before they could have access. And they didn't have more than a couple of days before INEC came back with an application they want to wipe out because they have to use the machine for another election. If you recall, in so many states of the federation, the INEC put obstacles on the way of petitioners to access the materials and information they need. Now you put the whole blame, the whole onus, because hearing the judgment yesterday, the recurring decimal was the petitioner failed, the petitioner failed. At some point, it was sounding like a rebuke to the petitioner for coming to court in the first place. All right? Now, if you are presuming regularity from a government agency like INEC, and it has been shown to you that there was nothing regular about what they have done. They uploaded materials on the net, and you have materials from Katsina in Port Harcourt or in Abia, you have from Abia in Maiduguri, all those kind of things. That rebuts that presumption of regularity. It should be up to the commission to show why it has to be believed. You put everything on a petitioner, just a political party leader, and he's not part of INEC, he's not part of the police, he's not part of the law enforcement agencies. You now want him to also prove. For instance, INEC put up a portal. They also manipulated the portal. And you want the petitioners to prove how INEC manipulated the portal. It is up to INEC to come forward with credible evidence that a portal, which they told Nigerians was the game changer, suddenly went off for a few hours and resumed the following day. And the few hours it went off were the critical hours when it had to be relied upon. You also said nobody can force INEC to electronically transmit the result. Did anybody intend to force INEC? INEC came out with regulations. And we are the ones who asked the National Assembly to give them money, public money, my tax money, my honest sweat. And it was given to them. They built up a portal and regaled Nigerians at various fora, from Mr. Yakubu to Festus Okoye to all of them, both within Nigeria and outside, about the game changer they had. And at the critical moment, they failed. And you are saying nobody can force them. Did anybody intend to force them? They made a promise, spent taxpayers' money, and failed. And instead of rebuking them, you are rebuking a petitioner who says, I relied on what my government official who took my taxpayers' money and blew it in the air did. But how can you be hard to say that? So it's a proper misdirection, because you get people who call themselves senior advocates try to dance around these things. Why is Nigeria perpetually a toddler? Why are we not making progress? In 2015, the card reader issue came up. All right? And the Supreme Court said, oh, it's not in the law, it's not this one. When you have a mischief in the law which has been identified, you recall the Saraki Senate even amended the Electoral Act which Buhari didn't want to sign. Even the Senate and the House did. It was at the last minute that he was forced by public opinion to sign. These amendments, some of them, were meant to cure the mischief that were discovered close to 10 years, 5, 7, 8, 10 years ago. And we are still repeating the same thing, we don't learn from our mistakes if they were mistakes, making me to believe that these things were deliberately planned and have the courts affirm them. And then what message are we sending? What message?
You know, when you say that, was anybody trying to force INEC to prove or to upload?
Upload, yeah.
But what about when, I mean, you all say that he who alleges must prove, and the lawyers know it. So isn't that a similar scenario that if you're going to court to say INEC didn't do this, you must be ready to prove your case?
Sorry. There are facts peculiarly within the knowledge of an individual or an institution. And in law, those facts, the onus is on the person to come and give evidence on why he shouldn't be held, that this thing should proceed in the normal course of things. You built a portal, or you commissioned experts to build a portal. When they finished, they reported to you. You were given the back end, the passwords. Your own IT technicians are the ones who are now in charge. The person who built it has gone. All right? And you made a promise to everybody, uncoerced. It's not like anybody forced you. You came out in public and said this is a game changer. So when you did not deliver, should I have the onus to show why you did not deliver? When I don't have access to the engine room, the back end, the passwords and anything, it is you who should come and tell us. And don't tell us things that don't make sense. Oh, you had a glitch. What is a glitch? You shut down a system, you say it's a glitch.
So on the flip side of this, listening to all of that judgment too, and then of course people will interpret certain things differently. But doesn't this also suggest that for some they think, okay, well, if this is the judgment and how it has come down, are they trying to also say, well, there are several loopholes in the laws. So if you don't want this to repeat itself, let us go back and correct our laws and be more specific about who needs to do what, particularly INEC, moving forward.
Yes, we have always had this idea of a new Electoral Act after every election. But this thing is beyond putting things down in a law. It's about a mindset. Because the way these judgments are proceeding to say, oh, show me where it is in the law, it gets to a stage, Chamberlain, where you'll be asked to show where it is in the law that you must eat. Or that after 2, 3, 4, 5 hours, you can visit the bathroom. It's about the mindset of the operatives, rather than saying, because you will end up with a 1,000-page piece of paper, right, called a law, which will be passed by a National Assembly and signed. But we live in a normal human society where you cannot anticipate all the issues and challenges that will come up. And somebody must always take advantage. Why are we always taking advantage to game the system? Okay? You say it is not in the law. What exactly, on what basis did INEC collect this money? Taxpayers' money. Blew it up unapologetically. Stop the parties from gaining proper access to the records they need. And all we hear, the judges who even gave the order, never at any time, we are angry enough to try to cite INEC officials for contempt. They were playing on. Nothing was wrong. So we can't make progress based on this. You see, let me explain to you. We all went studied law, went to the university, read jurisprudence, read evidence, read adjectival law. The truth is that any position you want to take in law, you can find a justification. Whether it is justice, whether it is about what the people expect of you. Listen carefully. Judges are public servants like every other person. They are supposed to interpret the law, not in a vacuum, to advance society. Otherwise, why were we blaming military dictators who made laws, okay, that we did not like? If we go on just this rabid positivism, oh, show me where it is written. Buhari, the former president who handed over to him, shot people because they were involved in drugs. And the trial, nobody can even verify whether it was a proper fair trial under those military decrees. And before we could say Jack, he killed them. Now we have a situation. The Constitution never anticipated that somebody who will be nominated by a political party will have a history of forfeiting money based on involvement in drug proceedings.
It's a civil matter.
No. It's not about that. Now, official proceedings are not civil matters per se. They are a hybrid. between civil and criminal matters. Okay, look at the Desiani case we have in Nigeria. You are suspecting, the government says, this money we found in your account or this property is beyond your lawful and legitimate income. Come and show us, it must have been the proceed of an unlawful activity, a crime.
So the character
come and show us how you got it. They do an interim order, which they didn't give you the opportunity to come. They now advertise and invite you to come and show how you legitimately got this money. And if you, once you're unable to do that, the court now says this must be the process of crime or illegality. And so the money is forfeited. So to tell me that it's simple civil proceedings is reading the law upside down. We all went to school. The fact that you became a judge doesn't, yes, you have a duty to perform, you have the authority, but it doesn't give you any special learning to turn very simple, straightforward things. Let me tell you something. Whenever you see a professional becoming extremely technical, speaking highfalutin Latinate jargons, is a sign that he doesn't understand his duty, because whatever you can say and whatever you want to express can be done in simple is and was that doesn't bewilder.
It's not legal jargon.
It doesn't need to bewilder anybody, because everybody's bewildered as how a man who could not contest the forfeiture of his $460,000, and you say there is no blame. He says you must be arraigned, you must this. Why did he not contest that? The Constitution didn't anticipate that kind of thing, that a man will be the president of Nigeria with what? Nobody knows when he was born, conflicting documents, nobody knows the schools he attended, conflicting. No, we can't continue behaving like that. When you get to the international airport, they say Nigerians this way, step aside, you complain. How did you arrive at that thing? So this is beyond just abstruse legalism. Okay, the petitioner failed. As if to say all we are coming was like the petitioners had to be rebooked.
Welcome back. It's still Sunrise Daily on Channels Television, and we're still reviewing the tribunal judgment on the petitions against the victory of the President Bola Tinubu. We have with us Mr. Onyekpere, and joining us again is Mr. Bayojo, former Attorney General and Commissioner for Justice, Oyo State. Mr. Onyekpere, let me just quickly follow up on your position, that the tribunal justices were more akin towards recommending the petitioners, for the petitioners failed to. But if we look closely at the position put forward by the justices, let me just read some of the notes here. The petitioners failed to specify the anomalies, where the anomalies occurred, the polling units that they occurred, where there was no election. They failed to state the scores that were used. As a matter of fact, the only female justice on the panel, in her own ruling yesterday, also observed that one of the witnesses that was asked about what he thought the scores would be had they won the election and had the results been uploaded to the IREV portal as at when due. He said, the witness said, how was he supposed to know when the results were not uploaded? So it would seem.
Opponent result, it is not that where they are making the mistake.
But Mr. Ojo, doesn't that defeat the purpose of Section 60 sub 5 of the Electoral Act, which says that the presiding officer shall transfer the results, including total number of accredited votes and the results of the ballot, in a manner as prescribed by the Commission? And the Commission by itself prescribed electronic transmission of results. Mr. Ojo, did you get that?
Oh.
It appears as if we've lost connection through to Mr. Ojo. Let's return to Mr. Onyekpere, who is with us in our Abuja studios. Mr. Onyekpere, perhaps we should now begin to look at other aspects of the ruling, particularly that brought before the court by the APM. If that has been dispensed with as a pre-election matter, please educate us why other issues like the disqualification based on the qualification of the president and his indictment in the US, why those do not also qualify as a pre-election matter. Perhaps you could educate us on that.
Well, the whole idea is that if there are matters that can be dispensed of before the petition itself or the election is conducted, parties should take advantage of that. But you also know that all those issues, most of those issues are matters within the exclusive jurisdiction of the parties, and an outsider cannot simply come in and start challenging those issues from another party. If you are not a member of the party, you are not even an official, you are not even a contestant in any of those primaries. But I think the important thing, the clarification I needed to say from what my learned colleague was talking about was that there was a mischief in the existing law, like the challenge of the card reader, okay, which they said was not part of the law. And the mischief also was that there's always this issue of results being exchanged or being manipulated in the night between the polling booths and where they are being transferred and the collation center. So the idea of this IREV was like, this is what happens. Everybody can be able to see it, so that when you get to the collation center and produce a result different from the one you've entered there, people can now say, wait a minute, this is not what we have seen, it is different. So by denying people the opportunity of seeing that, to be able to make a comparison, you've rubbished the background, the framework of transparency. So I'm not saying it should be compulsory, but once you make that, promise to the people and use taxpayers' money, you should not be hard to come back to say that it is of no moment, it is of no consequence. Can you be called to bring back the billions that were used to build a server? If you cannot build it back, you cannot be called back to bring it, then there is no basis. And my challenge to what happened is not that the difference between me and him, the point of departure, is that he's reaffirming the status quo. And I'm saying the status quo can no longer continue. It is wrong. That is why we are backward. That is why nobody is respecting our elections. And he's merely reaffirming the status quo, reaffirming what I say is wrong. So that's the departure. I am saying it has come to a point where we must change this jurisprudence, that you have possession of documents, that Chamberlain has possession of documents, has a blow-by-blow account of what is happening, and the Ezonyebere is put on the strictest proof of a matter particularly within your knowledge, of a matter you have a constitutional and statutory right to superintend. And I ask you to give me the information. You place all kinds of obstacles on my way. You block. And the course that gave the order that you should give me the information simply what two of us, as if to say we are not performing a public duty. So we can't make progress with that kind of jurisprudential mindset.
All right.
So if the law needs to be amended, so be it. If the constitution needs to be amended, so be it. And I'm even saying that even within the context of existing law, the judges did not exploit all the loopholes and parts of the law that would have given substantial justice. What they have read is technical justice. I agree with what you say, I disagree. That law, the evidence is this. Why are you rejecting the evidence of the Gambian passport? And then you're admitting some. What is the basis? Okay, so this is the point I'm making. I am not here to say the law as it is good. I'm come here to say we need to change.
Well, Mr. Yekere, on that particular one, I mean, just as you said, and I think a number of other legal practitioners agree, it's not going to be the only court of instance in this case. There are still opportunity, and I think the Labour Party has already said that they're going to make their case for what is next going forward. But speaking about our institutions, speaking about the judiciary as an institution, I'm happy you said that if there is a need to change the law, if there is a need to change the constitution, these things need to happen. But then the institutions are powered by these laws. These laws do not power themselves, they are powered by individuals just as yourself who make up the institution. So in terms of the process, in terms of institutional parameters,
in the name of national unity, in the name of patriotism. What is missing here, and what do we need to fix in order to retain the integrity and shore up the image of Nigeria in the Committee of Nations?
Transparency is key. We need to have an INEC that is not beholden to the ruling party and the powers that be, that is as much open to opposition parties as it is to the ruling party. We need to have an INEC whose word is his bond, particularly the word of the leadership. When they take taxpayers' money to say this is what we are going to deliver, they deliver it without equivocation. And not to tell Nigerians this is a game changer today, and tomorrow you completely deny and do a volte-face to the statement you made a couple of days ago. Maybe since we need everything to be in the law, we may need a 1,000-page Electoral Act which stipulates everything, including the time that electoral officials should breathe, and when they have to go to use the loo, and when they have to go and eat. Maybe everything, word by word, 1,000 pages should be there, so that nobody will have an excuse of trying to take advantage or game the system. My worry is that the message being sent to Nigerians is an unpalatable one. And the message is simply manipulate your way, be declared a winner, and then you place a very heavy burden and onus on the person who is trying to challenge you. So what you will see in the next election is that everybody will go all out, okay, to violate the law. And at the end of the day, we have this brazen situation where the law is held in contempt. To the extent that the law we have now and the judicial proceedings and processes we have now are returning the results they are returning, shows you that something is fundamentally flawed. And we need to change that. Otherwise, we will be left behind in time and space. Other nations are moving forward. Nigeria is a laughingstock in the Committee of Nations. We can't continue pretending. If we want to pretend, good luck.
Well, Mr. Ojo, thank you for joining back on the program this morning. So there's a question we asked yesterday, Bukola and I asked one of your colleagues in the inner bar, who we asked about awareness and education for Nigerians in terms of, from the example of what happened yesterday. And then we also asked about the legality of law, the morality of law, and the sentiments of law. Which one of them played up or was likely to play up more yesterday? And he referenced the fact that most of the time we seem to go with one. I'm not going to let you know which one he said. I'd like you to speak to that yourself. First of all, how much of this process would you say was educational enough for people to know how the judiciary works in Nigeria? And then in terms of the legality of law, the morality of law, and the sentiment of law, which one do you think we tend to go with more, as opposed to the one that ought to? Or unfortunately, Mr. Ojo has left us for this moment. But if you can take that on as well, Mr. Onyekwere, legality, morality, the legality of law, the morality of law, the sentiments of law, which one usually plays up more, as opposed to which one should play up more?
I think you are raising a very deep jurisprudential question. Now, if you look at our laws as we have them, murder is an offense, stealing is an offense. They are all based on moral axioms that as a Christian you talk in your commandments, thou shalt not steal, thou shalt not do this, thou shalt not commit adultery. And this is what transformed into laws. Now the question you are raising is, what gap should society allow between those moral axioms which everybody agrees is wrong and the legalism of what you put down on paper? Ideally, your moral conscience, the moral dictates of the society, should influence the codification of your law. Okay? Our sense of what is right and wrong should be what you find in the law. And once you find the gulf between that sense of what is right and wrong, is what is creating this scenario that we have now. It is not about lawyers like me or the SN or anybody speaking highfalutin here. Go to the streets and measure how the woman selling pepe or the man pushing a wheelbarrow, what is his impression about lawyering and judicialism? His impression is like some guys creating things for their own benefit, not for the benefit of the society. So we must, so it's not a legalism should take cognizance of the morals of the society, should take cognizance of the sense of right and wrong. Otherwise, legalism is a failure.
Okay, so as we wind down on this one, what about what you always say, that the law is not about what happens in the court of public opinion, you know, it's about how you can prove your case before the justices. But what do you then make of one of the justices when she said that she made reference to social media, pressure from social media, and people needed to prove their case as opposed to relying on some of those things?
Well, that shows that the judge is a human being. She reads the social media. Is he living in Nigeria? Whatever you see, like we are doing this morning, if she's not sitting, she could possibly be listening to us. So there is no way anybody can pretend that you are sitting there, you are not part of society. So that is why, yes, you need to prove your case before the court. And what I'm saying is that both the rules of the court and substantive law should, if they are not already in good state, should be rejigged in such a way that the votes will count. Because the intention of the Constitution to say, do not take control of Nigeria in a way and manner not recognized by the Constitution, is not only a warning against military coup. Rigging elections, which when you did not actually win, somebody else won, returns you, you are taking control of Nigeria in a way and manner not recognized by the Constitution, is the same as a coup, more or less. So what I'm saying in essence is that we need to rejig these laws. We need to rejig the procedures. The judges need to rejig their mindset. They need to ask, they need to raise the fundamental poser. What is the purpose of our sitting to adjudicate electoral disputes? If the answer he gave is wrong, they could answer the questions themselves, throw it open to Nigerians, and we arrive conclusively at a proper goal. So that you do not set questions for yourself. You leave the question society wants you to answer. The question is who won the elections? Lawful majority. It's not about any technical rules of evidence and things that nobody understands beyond the few who are lawyers.
Okay. But the other question is that before all these lawyers took up these cases and went to defend it, they knew all of these things. They knew that this may be the likely outcome. It could go either way. Someone will lose, someone will win, and then there'll be several other scenarios about the laws. So I just wonder, is it that they were surprised that it came this way, or they didn't know that, look, these are the kind of cases, but they're all experienced lawyers, senior lawyers.
That will also tell you, I mean, we are not discussing baby lawyers. These are big senior advocates who are experienced, who have done litigation at this level. In various other cases, some they have won, some they have also lost. So that tells you how difficult this procedure is. And that's why I'm saying there are things that you will need to prove your case. If it is not within your reach, and the person who has it is not in any way assisting, he keeps a mindset that he must obstruct you. Even if you were to resurrect the late Chief Rotimi Williams, there's no change. Nothing will change. So that's why I'm saying the reform should be about the roots, branches, the leaves, so that we have a new system. I expect the National Assembly to look at this judgment, although there's still a channel of appeal to the Supreme Court. But to be honest with you, I don't expect much. I'm not anticipating any change between what the Court of Appeal says. I wouldn't expect much change. I'm not trying to second guess them, but that's my own feeling with what I see has played out with the cases that.
But isn't that like a general principle that if cases the first instance go a certain way,
you must go upstairs.
Usually,
if you have the lever, I mean,
but they say usually if you go upstairs, chances are, if not over 90% of the time, it is the precedent that has been laid there that will always
that will also be used. Yes, that's what I'm saying. But I'm saying that some of these precedents we are citing did not take cognizance. I keep repeating, of certain facts. If I'm the only person who witnessed a transaction and I know everything about it, Timberlane, it will be extremely right and proper to say, Eze, you were the only one in this room with this cameraman. And he was very hale and healthy. And suddenly we come back 30 minutes after, and he's lying on the floor foaming. He has an injury on his head, which could have been done by an instrument. And I raise my hands to say, I don't know what you people are talking. It is right and proper to hold me to account for how he fell and what led to that injury. But if somebody else was here and I'm coming in from the room because I saw him first and raised the issue, you now tell me to go and do it. It's not possible. Even if I were a supercomputer, I cannot do it.
So shouldn't this be like a springboard upon which we will then say, as a society, perhaps those other lawyers who are involved could help us, will marshal out some of these quote-unquote loopholes that we've seen here.
Good.
And then say, okay, moving forward, because any country always has to think about moving forward.
That's true.
So we can then say, all right, in order to ensure that we keep rebuilding confidence in our